Thank you, ladies and gentlemen. One of the great resources of the United States is, I believe, our judiciary system. It's much better to be able to go to a court and resolve your disputes civilly and amicably than it is to resort to other methods, more brutal, of dispute resolution. And in the system of justice that we have in the United States, I think there's no more refined, elegant, sophisticated, respected, and informed judiciary than the judiciary that exists in the state of Delaware to resolve matters of business disputes and corporate law across a broad range of issues. The Delaware courts, as many of you know, are renowned at the Chancery level, which is the trial level, and also at the Supreme Court level. And we are honored in the extreme to have with us today the Chief Justice of the Delaware Supreme Court. Ladies and gentlemen, I give you the Honorable Myron Steele.
Microphone is now on. It's a privilege to be at Stanford under any circumstances. I just wish the weather were a little better. That would help my feeling of genuinely sincere hospitality. What I wanted to talk about tonight is the fact that typically Delaware competes with the federal government of jurisdiction over corporate law, and it's only appropriate that Justice Breyer would steal half of my class tonight or more before I have the opportunity to talk with you. But I understand the glitz and the glamour of Washington, D.C. under any circumstance, and I'm willing to let it boil down to who can get the job done better in the area of corporate governance, and we'll see how that plays out over time. What I wanted to focus on tonight are issues that will be forthcoming in the Delaware court system and forthcoming for redefining possibly long-standing principles of corporate governance. I'm going to assume, because there's a diverse group here, that some of the things I say will be something everybody already knows quite well and doesn't need repeated. On the other hand, I need to lay a foundation for the thesis of the speech. But what I really want to do at the end of the night is be able to have said that I provoked you into thinking about the issues on which I focus. And when I say provoke you, I mean really provoke you in the sense that I hope some of you are angry or upset with what I say, and others of you will simply take what I say and think about it, hold it in the back of your mind, and see whether the direction I predict we're going, or that we possibly could go as the common law continues to develop corporate governance, is the right direction, not just for an individual corporation, but the right direction for publicly traded corporations nationally, and the right direction, even more importantly, for our national economy. Now, it goes without saying that when some of us were younger, that a majority of shareholders in this country were individual retail shareholders. As time changed, the shareholder base has changed. And instead of a majority of shareholders in publicly traded corporations being people like Myron and Bess Steele, who invested with what academics have called typical rational apathy about the way in which the corporation ran itself, and all of we retail shareholders combined together had a collective action problem, people will explain in law school. How do such a disparate group of retail investors ever target issues within a corporation by acting together for positive change? And the answer for decades was you really can't get it all together, to put it in the colloquial. But the shareholder base has changed. And with a change in the shareholder base, we see 60 to 70% of the publicly traded corporations in this country with a majority base of shareholders ownership in institutional investors, some of which are characterized, either self-characterized or by others, as activist shareholder investors, activist institutional investors. The dynamic has changed with the change in the ownership in the shareholder mass. The one constant that remains, however, is the shareholder mass is still a diverse group of interest. Even within the institutional shareholder ownership, there are differing opinions about the way in which corporations should be managed, the direction of the long-term strategy of the corporation, and the balance of short-term interest versus long-term gain. You couldn't get a group of institutional investors together who would agree on a common plan or a common strategy. So the shareholder base remains diverse, but just diverse in a different kind of way. What this new change in shareholder base has achieved, though, is shareholders no longer practice what was the answer to problems that shareholders had with the management of corporations in the past. That was do one of two things. Vote the bums out at the next annual election. You would vote against a slate of directors if you could find someone to run against the slate of directors. And secondly, you would take what's called colloquially the Wall Street walk. You'd sell your shares and move on and invest in a corporation whose strategy was more in tune with what you thought would enhance your wealth. And it was widely considered that that was the shareholders' alternative, even though then as now, shareholders had the option to propose bylaws, have them voted on at the annual meeting, and try to restructure the internal governance of the corporation by bylaw change. But it was ineffective because of the difficulty of collective action that I mentioned just a moment ago. That has changed as well, because with the 60 to 70% ownership, even in a diverse group of institutional investors, we have developed as a result of the two crises within the last decade. The first I can characterize, I think, without fear of too much criticism, as the Enron WorldCom generated crisis, a crisis of confidence that directors of corporations would act in the corporation's best interest and would follow their own standards, their own internal standards of ethical conduct, as well as the overlay that comes from the state court systems of common law fiduciary duty. There was a loss of faith in the ability of directors to carry out their fiduciary duties. That's followed, of course, by the 2008 crisis. And I'm not a macroeconomist, and I don't know very much, I concede, about regulation of the financial markets. I know that there are many federal agencies, all of whom are capable of pointing the finger elsewhere to explain the financial crisis of 2008. And I know there are politicians who passed statutes and created agencies arranged for the purpose of lending money to people who couldn't afford to pay the money back, who are capable of pointing the finger elsewhere. And in one respect, the finger was pointed, and I'll take Senator Schumer's prefatory language to his initial shareholder Bill of Rights that eventually morphed into the 35 pages out of 2,300 pages that we all have for the holidays for Dodd-Frank. I think somebody's going to get around to reading the entire bill at some point. Maybe even the people that voted on it will read it in its entirety one day. Solution to that particular crisis was federal insertion of principles by regulation, authorized regulation by the SEC, or statutory mandates into internal corporate governance of state-chartered corporations. Now, happily at the end of the day, what emerged from Dodd-Frank that was of any significance for corporate governance is say-on-pay and proxy access. And I'll target that in both of those in just a minute, because I think there's good and bad to both. But I think the development of the concept of say-on-pay and its effect on litigation, which is my world, and the potential issues that arise out of proxy access, both will highlight this whole tension that exists today between shareholder empowerment and the traditionalist view that the authority to manage the affairs of the corporation is vested in the board of directors. A traditionalist view, and there might be one in the room, I'm not quite confident one way or another about that, or maybe I should say there might be another in the room. The traditionalist view is that Section 141 and its comparable sections around the country of the Delaware General Corporation Law vest the authority to direct the affairs of the corporation in the hands of the board of directors. Now, that's not to say that the shareholders do not have power. Shareholders under Section 109 have the power to propose bylaws. There are 5 critical areas demanding a shareholder vote before actions can be taken by the corporation. The board can propose changes to the charter, but they can't be effective until 66 2/3% of the shareholders agree and vote in favor of them. You can't sell the company. You can't merge the company without a shareholder vote approving that action. Obviously, shareholders elect the board of directors. Only 30% of the publicly traded corporations in the country today have a classified or staggered board as a result of market forces reshaping the way in which directors are elected. So the other side of that coin is 70%, a substantial majority of the publicly traded corporations in this country now elect the entire board of directors annually, which enhances the ability of shareholders to affect change at the level of the board of directors. The most efficacious mechanism for removing directors. Now, there is a statute that allows one to remove directors, but it's a very difficult process. It's usually not cost effective, and it usually creates such tension and disruption that it's rarely used. But in some cases, you can utilize the removal statute. But now, with directors being elected in total every year, it's far more efficient to try to defeat directors who've performed badly at the annual meeting. The other issue that has brought shareholder activism to the fore is executive compensation. You can quote statistic after statistic, and those who believe that the world is divided into the fortunate and the less fortunate, and that talent and work ethic has nothing to do with separating the two, the people that live in that world believe that executive compensation is out of control, or they don't understand the basis or the metric for setting executive compensation, and they're no longer inclined, as the prior shareholder base was inclined, to give management compensation the benefit of the doubt when the directors approve a compensation plan. That produced say on pay. In my view, the tension between the shareholder empowerment movement and the traditionalist view of the board-centric management of the corporation for the court system is going to boil down to 2 things. First, I remain confident that there's an accountability system in place through fiduciary duty that is present for private ordering and chastising of a board that fails to carry out its fiduciary duty of loyalty or care, or fails to conduct themselves consistently with carrying out those duties in good faith. And that accountability mechanism flows directly from the concept or the principle that when you grant someone the authority to manage someone else's money or someone else's enterprise in which they've invested, with that authority comes responsibility. And the only way to test whether that authority has been exercised responsibly is to have an accountability mechanism. That accountability mechanism is litigation and fiduciary duty, or vote them out of office. But in the meantime, you have the option of litigating to establish that there's been a breach of duty. Litigation in that context can be very effective and far more effective, in my view, than rule-based adoption of either statutes or regulations implementing statutes that try to address in advance what constitutes appropriate conduct by directors. The why behind my thesis is this: litigation individually targets corporations who have failed and makes the necessary change either by settlement or court order in the way in which the structure of the exercise of that authority works within that individual corporation. Let me take probably the most intuitive example. You will hear people cry from the rooftops without any empirical data to support it that you must separate the office of chairman and CEO. It's just wrong to have the chairman and the CEO be the same person. Well, the answer to that, to me, is, well, show me why it's wrong. If I had shares in Berkshire Hathaway, I would not want the position of chairman and CEO to be separated. I'd be very content with the way the corporation is being run. I think the person, though he may be 81 years old, that runs that corporation has a heck of a record, and I wouldn't want to disturb it by separating those positions just to placate some mantra being preached by people on a mission for change, which they like to construe as a mission for progress. Professor Davidoff from Cambridge University in England did a 50-year study of the English experience, and the English system, as you probably know, has a you must separate chairman and CEO or explain why not to your shareholders annually. He did a study, performance-based, which should ultimately be the test, that revealed that there wasn't any difference in the performance of corporations who separated the position of chairman and CEO and those who did not, either by having two separate positions or creating the highly fashionable lead director concept, which has captivated many people today in this country. The bottom line is, shareholder empowerment movement often wants change that gives them more authority to manage the direction of the corporation. So as authority shifts to them for political reasons more than economic reasons, the question becomes, what is the accountability mechanism when they exercise that authority to test whether they've exercised that authority responsibly? And the answer is, quite candidly, there is none. Will it fall to the common law to craft one? The common law crafted one on a fiduciary duty relationship basis by saying duty of loyalty, duty of care must be exercised in good faith, otherwise you're irresponsible in the way in which you've exercised your authority, and you will be held accountable for it. Let's take the possibility, a hypothesis, that a group of institutional investors get together, they decide they want to change the direction of the corporation. They use the tools at hand to do so, and one of the new tools will be proxy access. But let's just focus for a moment on a bylaw change that redirects the course of the corporation. And they do it in a Wolfpack mentality. People will argue that institutional investors have a short-term frame. They look for short-term, not long-term profit. Whether that's true or not, you can decide for yourself. But we do know that institutional investors have a quarterly reporting system. They have to show the people to whom they owe fiduciary duties that they're performing successfully on a quarterly basis. It's not surprising that they want quarterly returns from the corporations in which they invest. It's not surprising that their time frame for investment, which they tend to characterize as long-term, is 2 to 5 years. Now, again, I'm not a macroeconomist, and maybe in the tech world, 2 to 5 years is long-term. But in the rest of the corporate world, I'm not sure that developing products to compete internationally, developing new systems through R&D, and putting equity in place for developing new products is quite the same thing as declaring a dividend or buying back shares that look like a short-term return, or pressure on a board to declare dividends or buy back shares is the best way to utilize the cash in the corporation as opposed to R&D investment. The question is, who's charged with the authority to make that decision? And what do you do when that decision is made irresponsibly? With the directors, you have an accountability system. With institutional investors, particularly acting in a Wolfpack mentality, coming together as if they were controlling shareholders, as if they had a majority of shares, and forcing change in the direction of the corporation that suits their short-term interest. What about the rest of the shareholders? What about Myron and Beth Steele, who invested for the genuine long-term? Or, now, you can look at me and tell, investing for the long term is a different concept for me as well than it was when I was 30 or 40 years old. But certainly when I was 30 or 40 years old, my view was to invest for the long term. I was the ultimate rational apathetic. I didn't have time to deal with anything other than the practice of law. So I invested in what looked good to me on the information I had, and then I let it sit there and had confidence in the board of directors to manage the company. I wasn't looking every quarter for short-term returns. I wasn't looking for a 1 year or a 2 year time frame. Then I'd move my profit somewhere else for another 1 year, 2 year time frame. So my interests are not the same as the interest of the institutional investor. Now, if there is no accountability mechanism for the institutional investor, and if the institutional investor consistently with the law, which says the law leaves shareholders free to act in their own best interest unless they're actually a controlling or a majority shareholder and have, in effect, control of the board. So individually, consistent with the law, they can move in whatever direction they want to comply with their own best interest. But when they get together as a group, acting as if they were a majority, in a kind of consistent plan to redirect the corporation, and other shareholders are harmed as a result of their decision-making, what remedy does the law provide? And the answer is, as of the time I'm standing here tonight, and as the time we're thinking about it, hopefully we all are thinking about it, there is no accountability mechanism. So the first question in this tension between the change in authority is, will the common law develop a mechanism to hold institutional shareholders accountable when they act contrary to the best interest of the corporation, if that can be defined in a discrete circumstance, or harm the minority shareholders who aren't a part of their short-term vision? Much like science, equity tends to move in where the law doesn't have an answer and shapes a remedy. One of the maxims of equity is, for every wrong, there must be a remedy. So I suggest to you that over the course of time, maybe not this year, maybe not next year, maybe not 5 years from now, maybe after I'm long gone, someone will have to confront the issue in the state court system about whether or not equity does craft an accountability mechanism to test whether or not the institutional investors acting together constitute the same danger that's constituted to minority shareholders by a controlling shareholder, and therefore have to answer within the same framework as a controlling shareholder would have to answer. The second way in which authority is shifting will come from proxy access, because it's obvious that one of the problems that shareholders have had over the years, even if it's an annually elected board as opposed to a classified board, is actually being able to run a slate to oppose the board. And the difficulty with it hasn't been following the rules for running a slate, or it's expensive and it's difficult. The problem has been getting reimbursed for those expenses. So the real, if it's a positive, the real positive that comes from proxy access is the opportunity to be reimbursed by a successful effort in running a short slate for the board of directors from the treasury of the corporation itself, not having to pay out of one's own pocket, at least to the level that the board or the corporation spent running its own slate. That'll be a terrific incentive for activism in terms of running a short slate to change the complexion of the board, even if it takes 2 years to change a 9-person board by running a short slate of 3 in 1 year and 3 in the next year. The question becomes, what qualifies within each individual corporation a shareholder to have the opportunity to run the short slate and ultimately be reimbursed? You know from the SEC rule that was proposed and struck down by the DC Circuit that the thinking of at least 3 members of the SEC, apparently there's nothing all 5 can agree on, but 3 of the members of the SEC concluded that holding period of 3 years should be required and skin in the game to the extent of 3% of the shares for those 3 years. That means it would discourage frivolous attempts and expensive multiple attempts by shareholders. It would be disruptive and create chaos in the management strategy that's in place at the time. But I posit this hypothetical to you. Now that there isn't a 3-and-3 rule from the SEC, and there's some question about whether the SEC, having been short-pantsed by the DC Circuit, is going to revisit a federal rule, If the states are allowed to experiment with various forms of proxy access, and Delaware has made all of its chartered corporations eligible for proxy access since August of 2009. It's now appropriate for shareholders to propose their own slate, or for a third of the board. And Delaware has put no limit on a holding period, no limit on the amount or percentage of skin in the game. Each corporation can craft it for themselves. So here comes the tension in proxy access and the tension between shareholder empowerment and board action. Remember, shareholders can propose a bylaw. What if the board says, we're getting out in front of the bus here. We're going to propose a proxy access rule. Our shareholders will love it because we're going to be very progressive. You know, anytime you use the word reform, you're immediately progressive. You don't ever say, I'm going to change things, because that's neutral. You have to say, I propose reform. That means you're progressive and you're ahead of the game and it's a good thing. We have that mindset for some reason I don't understand. We don't just think of it as what it is, which is change, and we'll have to see whether it's good or not over time after we experiment and gather data to support what works and what doesn't work. But at the federal level, everything is reform and everything is the right answer, and it's only that answer. And there's no chance to experiment. And if it doesn't work, Congress never revisits it to see why it didn't work, discover what the unintended consequences were, and fix the problem. They move on to the next crisis and other issues with great faith in their own ability to run the entire railroad. But let's suppose a shareholder, active or aggressive or otherwise, proposes a proxy access rule that differs from the board. The board says generously 2 and 2. Shareholder says no. I'm proposing a bylaw at the next annual meeting that says 1 and 1. And the shareholder proposal for a 1-year holding period, 1% skin in the game, wins, gets 51% of the vote. 49% of the vote, one extrapolate, supported the board higher rule of 2 and 2, but 51% supported the lower shareholder proposal of 1 and 1. At the end of the day, which bylaw wins? Because you can further hypothesize that the board says, I'm not dealing with that stinking one-on-one. They don't understand what that will mean to the corporation. We'll be fighting every annual meeting at great expense to the corporation, win or lose, and at expense to the shareholders. It'll be hugely disruptive. It will take our eye off the ultimate ball, which is to have a business plan that we follow, we implement, and a strategy that works and allows us to compete. This is a terrible misdirection of the energies of the board. So they pass a bylaw that repeals the shareholder bylaw, which they have the legal authority to do. There obviously will be a challenge. Whose bylaw, at the end of the day, is the effective bylaw? Who is the last person standing, so to speak, in this gunfight at the OK Corral? Where's the guidance from the law on the ultimate answer? Well, I don't know what the answer will be ultimately, but let me phrase the question, because you win when you get to phrase the question, right? You phrase the question in a way that suggests that you have the answer and the answer is right. I suggest to you that there are 2 reasons why the board bylaw would and should prevail. The first is, at the next annual meeting, the shareholders can vote that board out, remove them from office. They will have to be replaced by a board that will understand why it was defeated for re-election. The second reason is the direction from the Delaware law, at least, under 141, says that it is ultimately the board that manages the affairs of the corporation. And implicit in that is that board is the only neutral group that can analyze the interest of the 51% and the 49%. And I admit, it's a little more intriguing to make it 51-49 that's 70-30. But the board is the only entity that can be dispassionate about the perspective of the 51% voters and the 49% voters. So it's not simply, it's not an Athenian democracy. People don't show up at the annual meeting, raise their hands, and that's the right answer. It's a Republican with a little r democracy. Now I have to say, Republican with a little r, because there are no Republicans left in Delaware. So I have to make sure I'm not referring to the dinosaurs when I use the word Republican. The answer to the question is, it is the board who's uniquely suited to represent the interest of all the shareholders and to look from the perspective of what's in the best interest of the corporate entity over the long term, and not the short-term interest of the short-term investor. Let me commend to you, as I close, because I was told I should close for questions, two particularly salient law review articles that deal with the shareholder empowerment movement. One is by probably the most well-known proponent of the shareholder empowerment view. That's Professor Lucian Bebchuk of Harvard, who wrote an article, it was in the University of Virginia Law Review, called The Myth of the Shareholder Franchise. And his basic thesis is giving shareholders the bundle of 5 voting rights and giving shareholders the ability to remove a board is an insufficient expression of the rights of ownership. He believes shareholders actually own the corporation as opposed to having a bundle of rights associated with share ownership. And his article says why we need this change and a movement toward more of a corporate democracy, more shareholder involvement in running the company. Immediately following it, in the same edition of the UVA Law Review, is an article by Marty Lipton and Bill Savitt of Wachtell Lipton, which is, I think, amusingly titled The Many Myths of Lucian Bebchuk, which goes through the traditionalist views and shows why his thesis is bogus. Now, I mentioned both, and I suggest you read them for yourselves, and you can see all the issues neatly capsulized and all the issues neatly explained, and it shows you the reformist view, the view for change through the eyes of Lucian Bebchuk, and then it shows the traditionalist view from a law firm that's widely known for representing directors, representing boards, representing corporate America, and their take on this balance between shareholder empowerment and board authority. And then for those of you who are law students, you have a unique opportunity because it will be your world where all this is worked out. And you'll see it play out in reality. You'll see which of these two theses ultimately achieve the only real objective that means anything to somebody like me, and that is all of this change should be directed to one goal: improving the performance of Delaware chartered corporations, or if you will, all United States publicly traded corporations, although I'm a bit provincial in thinking of the Delaware corporations first. But if the ultimate goal is performance, and if you give the benefit of the doubt to both views that each want to improve performance, that they fundamentally believe that corporations are the best mechanism ever devised by man to enhance the wealth of society generally, not just the investors in the corporation, not just the people who manage the corporation or direct the affairs of the corporation or are employed by the corporation, but it enhances the wealth in the entire economy, then you can read for yourself those two competing views, see them well documented, and follow later in life to see whether or not, when I posit to you that the two ways in which this is going to play out is the collective action by institutional investors and the potential imposition of fiduciary duties on them if their decisions trump the board of directors and they turn out to be beneficial to short-termists but a disaster for the corporation as a whole. Will there be an accountability mechanism put in place? And then secondly, through say-on-pay and proxy access, will the shift in authority result in decisions that rebalance that shift and follow the extent to which both the federal government and state action through the common law tend to move in one direction or the other? At the end of the day, I hope we'll all be able to say whichever way the guillotine falls, that it will improve performance of our nationally traded corporations. That's the goal, I think, that we all ultimately have in common. I'm happy to take questions. I won't even assume that those who didn't clap disagree violently with me. I'm willing to accept that. Oh, boy.
No, not at all. Your Honor, at least 2 of the 5 members of the Delaware Supreme Court, I'm thinking of yourself and Justice Jack Jacobs, have spoken for the last couple of years about the likely evolution of an accountability mechanism that looks at shareholders. I haven't seen any activity in the way of cases being brought. Are there those cases, and how do you see them coming?
There are two variations on the theme. Michael Wachter and Ed Rock at Penn are developing an article, as I understand it, to address fiduciary duties as they apply to proxy advisor services, to determine whether or not, if ISS, by way of example, tells a number of the institutional shareholders who follow their advice in lockstep to do X and it changes the direction of the corporation, it turns out to be a disaster. And of course, at the end of the day, you have to have harm and be able to prove harm that's directly related to that decision. That's not an easy task, which is one of the reasons I don't think you've seen a case develop. That's one aspect of what I might call expanding the scope of fiduciary duties. And ISS is largely a contractual relationship and not really a fiduciary relationship, so it won't be easy to craft a fiduciary relationship between ISS and the corporation's shareholders themselves, whether it's an institutional shareholder that takes advice from them or not. So that issue hasn't come up, but it's on the table. No case has said that the Wolfpack mentality equals controlling shareholder equals the same imposition of fiduciary duties as would be imposed upon a controlling shareholder. No one's been able to establish that that synergy exists, that acting in concert exists, almost as if it were a breach of fiduciary duty or aiding and abetting or a conspiracy to breach fiduciary duty. No one has formulated from any existing fact situation a basis for creating the duty as of yet. It depends, I think, on how far the authority ultimately shifts. And is there a break on that shareholder empowerment movement that means it'll never show up? Say on pay didn't turn out to be mandatory, it turned out to be advisory. But there have been 9 lawsuits filed against boards alleging breach of fiduciary duty on the part of the board for corporate waste, for failing to respond to a say on pay negative vote, or failure to craft an executive compensation system that caused the vote to be, though advisory, negative. And 2 of those 9 cases have been settled. The net result, changes in the say on pay package that was developed by the board, but in the minds of some people who believe that litigation is a cottage industry, it's also resulted in over $1 million in attorney's fees for the people that brought the suit. Now, there were only 37 no votes on say on pay, even though Dodd-Frank says it's only advisory, it doesn't impact fiduciary duty by creating a new fiduciary duty, nor does it change the existing fiduciary duties, for which many of us who grew up in this system are grateful, because to my knowledge, federal law doesn't have any definition of fiduciary duty. It's a common law concept, and thank God Congress hasn't decided that it can define fiduciary duty in 2,300 pages, or even 35. But there has been no case that has posited a fact situation to raise the issue as of yet.
Right here. Quick question on your view on how corporate law plays into, I guess, serving the purpose of protecting individual rights. You kind of described the idea that the purpose of corporate law is to try and improve the performance of corporations for the purpose of benefiting society as a whole, but at the same time disagree with the idea of, I guess, administrative laws which try to dictate how corporations should go about making those decisions, how boards should make the decisions, how maybe managers should make those decisions. And criticize the idea of institutional investors kind of grouping together to dictate the outcome of corporations because you're of a concern that they may be too short-sighted in their decision-making, which may hurt corporate performance. But considering that they are the owners of the corporation, isn't it their right to decide what's the best and what's the proper standard of good corporate performance? And that's kind of a specific question, but the broader question is, what's the role that, I guess, from your view, corporate law should play in attempting to, instead of guiding corporate performance, simply encourage freedom of choice and the protection of property rights of owners, whether they're institutional or individual?
Okay, well, first, I disagree with your premise. I don't believe, and nor does the traditionalist view believe, that shareholders are owners of the corporation. Shareholders purchase, by virtue of purchasing shares, a bundle of rights for the period of time that they own the shares. The corporation will exist after they sell their shares. The corporation will continue to exist, being managed by a board of directors. They are temporary purchasers of a bundle of rights. Those rights are contained in the corporate law of the state in which they are chartered. They're contained in the charter of the corporation in which they invest by buying shares, and they are contained in the bylaws of that corporation. And anyone who purchases shares in a corporation should understand that the corporate law of the particular state in which the corporation is chartered is similar to a constitution. The charter is similar to a statute, and the bylaws are similar to regulations. That is what shapes their relationship in the internal governance structure of that corporation. But they are only temporary holders of paper accompanied by rights. They're not owners of the corporation. They're in and out, in and out, in and out, each for different reasons for differing periods of time, each wanting, some wanting dividends, some wanting money invested in R&D, some wanting their shares bought back at a higher price to enhance their value in the market if they actually don't tender. There are all kinds of issues that touch on the rights they're willing to sell, buy, or hold. But they are not owners of the corporation. I know that the shareholder empowerment movement talks in terms of shareholders being owners, but I don't agree with that. Pardon? The corporation's a bundle of contracts with relationships together. It's an entity that has it's a citizen, it's a chartered citizen of a state, it has a life of its own. The shareholders elect the people to manage the investment that they have put into that company by virtue of buying shares. That's the board of directors. Those are the people who direct the course of that entity. It's a changing flow of relationships over years. But on no given time can you say that a group of shareholders, because they are owners, should be able to dictate the strategy of the corporation unless there's a change in the charter, a change in the bylaws, or a change in the common law that says along with that authority that you're going to assume, in order to assure that you exercise that authority responsibly with concern for your fellow shareholders, there will be an accountability system. There is one for directors. There isn't one for shareholders. I'm not trying to persuade you. That's my view. That's all. So the earlier, your prefatory question before you ask the broader one, the answer is no.
Mr. Justice, I'm the chair of the, I'm a practicing lawyer, but I also happen to be the chair of a compensation committee of a public company. And I wanted to comment on say on pay and ask your reaction to my reaction. There has been in place for quite a while the institutional shareholders advocating withhold votes on committee members, comp committee members, if they don't like pay packages. And now we have say on pay. I will make an observation as a comp committee member that I took far more seriously the number of withhold votes I got than the number of say on pay proposals that may have been made by the shareholders. I think that echoes your comment that that is a motivating factor for comp committee members. And I'd just like to have your reaction to my experience in that regard.
Well, I think it's very clear that one of the objectives of say on pay, even as an advisory vote, is to send a message to directors that when you are up at the next annual meeting for re-election, if you are proposed on the slate and you want to continue to serve, you will pay a price for a compensation package that did not meet shareholder approval. Now, there were only 37 out of 2,300 companies that got a no vote. And the question I ask myself, because I think there's a positive from say on pay, is say on pay, even in advisory capacity, even with the chilling effect on re-election on directors, members of the compensation committee or the board in its entirety that approved the package, it encourages boards to communicate better with shareholders. A smart board will talk to shareholders about the compensation plan before it's in place. Find out what the negative views may be from substantial, sophisticated investing institutions in that corporation. Explain why this is the package that the board believes or the comp committee believes is the appropriate executive compensation package. How it relates to performance, which is what investors really, I think, are focused on today. They've seen these metrics in the past that are comparables with other companies, and there's a disingenuous, from time to time, selection of the comparable, and there's this fear that we have to pay our executives 75% of the norm, but the package isn't targeted to their particular performance over a defined period of time, and there are no stated goals in performance. I served on a board for 11 years, and the most difficult thing in the world serving on that board, in my estimation at the time, now admittedly it was a regional hospital, so it's a 501c3, it's not a multi-billion-dollar multinational corporation, but the hardest work we had to perform as board members was trying to fix compensation in a way that would let us keep good talent or let us draw better talent or run the risk of losing the talent we have and trying to find somebody out there that would do as well or better and maybe redevelop a whole new strategy for that particular entity. Say on pay will be a good, positive effect if boards are smart enough to react to it in a way that creates transparency, improves communications, and particularly those companies that get a no vote, they should immediately meet with the shareholders, get an understanding of why, and tweak the compensation system. If they don't do it voluntarily, they're going to find themselves sued, as 9 have been sued, for a breach of fiduciary duty in a derivative suit, and they'll settle for the same terms and change in the compensation package that they could have made before the vote and avoided a no vote. And the difficulty of being on a board who has received a no vote is part of the old concept of shaming, the same as the reputational, the demise or the less reputational value in that director for having a no vote, having served on the board and approving an executive compensation package, is the same way of losing a breach of fiduciary duty suit. I think that aspect of say on pay, even though I personally do not like the fact that it was instituted by the federal government, it could have been done voluntarily, as many companies like Aflac did even before it went into the statute. I would rather have seen it experimented with at the state level, but that's all water over the dam now. So I'm looking for all the positives I can get from say on pay, because it is an increase in shareholder authority, but if boards handle it correctly, it can be a huge positive. Oh, I'm sure. Well, I'm hoping that board members will focus on the fact that creating an atmosphere that encourages a new cottage industry of derivative suits on the basis of failure to communicate properly with your shareholders and give them an understanding of the executive compensation package, it should be shameful. I wouldn't want to be in a position of being sued derivatively for an act of waste and overcompensating management after a no vote without making immediate changes and getting management to agree to those immediate changes. We'll see how it plays out, but I do think at the end of the day there's a genuine positive that will come out of say on pay. Well, no, I understand that. And I think that's one thing that the advocates of say on pay wanted to achieve at the end of the day, and that is to put pressure on board members to relate to their shareholders and understand the concerns about executive compensation and target that compensation package more directly toward performance in that particular company than some kind of widespread comparable metric that says we have to pay 75% of everyone similarly situated pay in our business sector. That's a mechanism that has failed. It's been used, the Hay system or whatever it's called. I can't remember off the top of my head. It's been used for years, and it's failed. Yeah, exactly. And you don't want your, as I understand it, there's a concept that I don't want it to be perceived in the marketplace that our executive didn't get paid at the 70% level like his competitor. It will look like we're sending a signal to the market that he's underperformed. That'll affect our share price. It'll affect the expectations of shareholders. So we have this attitude we've got to pay him or her what our competitors are paying him or her in that entity. And it's had a ratcheting up effect of executive compensation for a decade or more, and it's stimulated a very adverse reaction. So the time now is for boards to start talking seriously with shareholders about the executive compensation package ahead of a say-on-pay vote. And next year, those who got the no have to explain the circumstances of change, if any, and explain to the shareholders, as I understand it, under Dodd-Frank, give some explanation for why there was a no vote and what they've done to respond to it. And shareholders will judge them on that response. Sorry, do you have a question?
It sounds like you see problems in what the federal government is doing. I wonder on the other side why you don't see a race to the bottom, and I'm going to pick Cayman Islands. Why shouldn't AT&T, instead of being in your state, under your regulations, the federal government, reincorporate in Cayman, where they don't have this, and stockholders can buy and sell whatever rights they get? What's the advantage of being in Delaware or being in the United States under this type of problem you see?
Well, the advantage for years has been the United States was a source of equity without parallel around the world. That's changed. You can argue about why that's changed or not, but look at the IPOs over the last 10 years. Ever since Sarbanes-Oxley, if you look at the IPOs in this country, on a graph, they've gone like this in London, in Singapore, in Hong Kong. They've gone like that in the associated British territories, the Jersey Islands, the Virgin Islands, the Caymans, as you've described. Now, I'm in a 12-step program. I only worry about that over which I have some control. So it's the Delaware system. The Delaware system is what I manage. I don't have any effect on why somebody would be able to choose somewhere else. What we try to provide to our chartered corporations, encourage people to charter in our state, is walking that tension that I described right down the middle and finding the appropriate balance in corporate governance between shareholder empowerment and director authority, and not be perceived to have gone too far one side or the other. And that's not an easy job, and we have to do it on a case-by-case basis because happily our legislature does not interfere with independent populist tweaking of the general corporation law. And the bar has a sensitivity toward what its clients want. They present legislative change to the legislature. The legislature doesn't engage in a robust debate from left and right. It's considered a nonpartisan opportunity to keep Delaware in the forefront. So we try to adapt ourselves to change as best we can. The traditionalist view that I largely espouse tonight for the purpose of provoking as many people as possible, and I hope I told you that in the beginning. I hope I sent that message. You cannot trust me. You cannot think that I will write an opinion necessarily entirely consistent with what I said tonight, because we work in the common law system where contextually the facts will dictate to us what principles of law need to be applied, and we'll have to see how they're applied. The only thing I can ask you to trust me on is that we're aware of these issues, we're sensitive to these issues, and we try to create the right balance of corporate governance between the concerns of shareholders, whether they're institutional shareholders, retail shareholders. We don't distinguish between them. They're shareholders. We protect their bundle of rights. We will look at any attempt by a board to manipulate those rights in a way that diminishes the role of shareholders that's intended by our structure, and we'll punish the board who does so. On the other hand, the business judgment rule and other mechanisms cause us to be deferential to the board where there's no factual situation that suggests the board is not entitled to that deference because they're either interested in the outcome, they lack independence, or they've acted in a way that's a conscious disregard of their fiduciary duties, which to me, that means acted in bad faith. So it's not an easy job. And as much as I may seem relatively passionate about the traditionalist view, at the end of the day, it's getting that right balance, getting it done thoughtfully and neatfully, and writing an opinion that produces our most important product. Remember the old GE, you and I can remember the old GE commercial, if you don't mind me saying so. I'm not sure everybody in the room can. But our most important product are predictability, consistency, and clarity. We don't jump quickly to one side or the other, and we have to wait for the right case to come about to effectuate change. I'm only suggesting to you that as this movement gains strength, we're going to have to address these issues. How they're addressed at the end of the day will depend on the unbelievably excellent quality of lawyering that we see in our two courts on a regular basis. Lawyers from all over the country come to Delaware. One of the great blessings in my life is the opportunity to see fabulous lawyering. Brilliant briefs followed by amazing oral arguments, and I can walk into an argument on a Wednesday and say, I have a pretty good idea how this case is going to come out. At the end of the oral argument, I may do a 180-degree turn because the light bulb suddenly comes on, just like it used to do in law school after the first year. Never came on for me in the first year, but after the first year, the light bulb came on, and things started to make sense. Yes? Whatever. I don't know what the order is. Somebody help me with this.
I just had a quick question, and I'll pass it down. But regarding the shareholder being an owner,
Yeah.
and if in fact the shareholder isn't an owner and I just buy a bundle of rights, does that fiduciary, is inherent in the bylaws or that contractual relationship with me and the board, then is that where their fiduciary responsibility exists to me, or how do you define that?
What, in my view, it's only my view, I wouldn't even suggest to you that the other 4 members of my court would agree with the way in which I've articulated it. I think at the end of the day, we'd find some common ground, but they may not agree with the way I articulated it. When an individual or a group of individuals, like a board of directors, are making decisions that affect the investment of other people and over which those other people cannot affect the direction of that investment, then they owe a fiduciary duty. Stems from the original agency law.
And that has nothing to do with ownership. So you're saying that's distinct and separate from any ownership?
I'm saying that by the purchase of the shares, you have bought an interest in the corporation in the form of the bundle of rights that come with that share. That's an investment that someone else is going to manage for you. Doesn't mean you own the company in the sense that you can direct the strategy of the company, you can decide the direction in which it's going, or you can decide how the relationships are going to be formulated, or who's going to be hired, who's going to be fired, the extent to which the company ought to focus on the community, the extent to which the company ought to focus on the environment in producing its products, the extent to which the company should be focused on infrastructure and paying its taxes on time. That's not your role. Someone is managing all that for you, but managing your investment as a fiduciary. But it doesn't mean, like you own your car, you can drive it wherever you want to. It's not ownership in the classic sense, at least in my, it's not a race that you own that you can manage.
But that's where that fiduciary responsibility, because they are in charge of directing my investment.
Yeah, yes.
That's an absolute.
They're
Do you see that as an absolute
they're-
obligation?
They're managing somebody else's investment, and in fact, traditionalists view that investment as a passive one. The extent to which it becomes less passive and more aggressive in the sense that authority shifts, that's where you have to figure out some kind of accountability system to take into account the diverse shareholder base. Yes?
State law mechanism for accountability. I mean,
Yeah, I'm not talking about fraud on the market. I'm not talking about disclosure issues.
institutional investors owe a fiduciary obligation to the people whose money that they're managing, and so
Yeah.
the people who are voting shares, the people who are engaging with companies or making decisions about how to steward those investments owe a fiduciary obligation under federal law to the people whose money they're managing. So they have to be acting in the best interest of their clients, or else they can go to jail. And then the second piece of that is they also, under ERISA regulation, for those who are managing ERISA money, have even higher standards of fiduciary obligations that are put on them at the federal level. On top of that, there's also federal regulation around coordination and communication between shareholders and as they're acting in the context of communicating with companies. And so I guess I'm wondering, number one, if you don't think that the federal standards of accountability are sufficient for investors, why not, and why does it make sense to add more accountability at the state level? And the second question I have is, how do shareholders act together in Wolfpacks? And can you give me any examples of that? Because my understanding is that shareholders are actually extraordinarily restricted in how they can engage together and in communicating with companies under federal law at least, and perhaps under state law in some jurisdictions. And I'm just wondering what those two
Okay, let me take the first question first. I wasn't suggesting that institutions who have a fiduciary relationship with the people whose investment they manage, like a pension fund, don't owe fiduciary duties to those pensioners. They do. And they are accountable for that fiduciary duty under state law, irrespective of whatever federal accountability scheme may exist. What I'm talking about is when they start acting consistent with those interests, but in a way that is misdirecting the corporation in which they've invested, and in a way that's harmful to the minority shareholders of that particular corporation, they owe no fiduciary duties under state or federal law to act in the best interest of the corporation or the minority shareholders unless they're deemed a controlling or majority shareholder. That's the accountability that would attach for harming the corporation as an entity or the minority shareholders. Well, how is it? I don't understand how it's categorically impossible for them to do that. Well, let me posit it to you this. Well, let's assume that you have a group of, and these are hypotheticals. I haven't seen the case yet, but let's assume that 3 institutional shareholders take the advice of ISS because that's what their internal policy says, or like the Florida State Employees Pension Fund, it's what the state legislature by statute says they must do, follow the advice of ISS. I don't know how that affects the federal fiduciary relationship that you were talking about. Looks to me like an abdication of common law fiduciary duties, but they're following their state law. They vote consistent with ISS recommendations, and that vote misdirects a corporate strategy of one kind or of another, whatever it may be, and it destroys the value of the corporation and harms the minority shareholders. My point is simply this, that if we're going to move to a different regimen of exercise of authority in managing a corporation and enhance or increase shareholders' opportunity to direct the long-term strategy or the short-term strategy of the corporation, then they have to have an accountability mechanism. Well, I agree. Well, let's suppose they pass a bylaw that instructs the board. Think of the CA case that went to the SEC, and the SEC asked for the opinion under Delaware law of the effect. They were trying to effectuate a proxy access scheme that would allow them to elect to the board, before the proxy access rule, candidates for board membership that would follow their short-term interest. Let's assume that happens. They get on the board, they're confused about the law. They think that because they were elected by this group, they owe fiduciary duties to that group that elected them, and they act in concert with what they perceive to be the interests of that group and misfocus themselves on the fact that as soon as they're elected to the board, they owe a fiduciary duty to the corporation as a whole, and they can't just follow the dictates of those that elected them. Now, I know there's some people that might quarrel with that dual fiduciary duty, and I respect that view. It'll have to be played out over time, but then their decision-making results in short-term gain for the people that elected them and long-term disaster for the corporation as an entity. Are they responsible for that, the people that promoted them as candidates, or with instructions to act accordingly? Is there a factual basis for saying you assumed by acting as if you were controlling shareholders that you have a fiduciary duty to minority shareholders, and have you breached that duty? I'm not sure the fact situation will ever work. It's like in a way, it's like the institutional investors are like the Middle East. My enemy's enemy is my friend. Not all institutional shareholders have the same view of life. And then you have, on top of that, ARBs that come in and buy shares just before a particular action may be taken by the shareholders of the board. So it's a mix that may never come together with the commonality that create the construct that I've been talking about. My only point is, be careful what you wish for with shareholder empowerment, because if you shift authority without an accountability mechanism, where do you leave the minority shareholders at the end of the day? You could argue helplessly. Now, I hope you're right. I hope it never occurs. More importantly, I hope it doesn't occur before May of 2016. After that, anything goes.
Thank you for your remarks, and I'd like to ask sort of a follow-up question to the Wolfpack question that was just given. As the law develops and as fiduciary duties are made and as they are refined, obviously the common law is going to play a big role. And as you said today, the federal government has made moves into corporate governance that may or may not be welcome. I'm a student in a corporations class right now, and today we had a really interesting conversation between Randy Barron, a plaintiff's attorney, and Rochelle Silverberg, who is an attorney at Wachtell Lipton, and they had a very interesting conversation about how shareholder suits in Delaware corporations are moving out of Delaware since the mid-2000s, and I wanted to hear your views about how Delaware is going to play a role in developing corporate law going forward, and whether that role is going to diminish as suits move outside of the state.
Okay, I believe that litigation is a form of private ordering that brings a benefit in the way I described earlier, because it neatly targets an individual corporation and effectuates change within that corporation. Suits may move out of Delaware if the plaintiff sees value in uncertainty. For almost every plaintiff's case, you can add a 0 or 3 onto the case if you can find a jurisdiction where the judge doesn't understand the concepts of fiduciary duty, doesn't understand what a derivative suit is all about. Speaking of Wachtell Lipton, Ted Mervis tells a fabulous story about going before a district court judge in Texas, and he was trying to explain the demand excuse rule in a derivative suit. And he says, the Texas judge said, "What do you mean, Mr. Mervis? What fool would ever conclude they should sue themselves?" And the whole concept was foreign to that particular judge, because on Monday he might have a RICO suit, on Tuesday he might have a Jones Act suit, on Wednesday he might have a drug case, on Thursday he might have a Social Security appeal case, but it wasn't generally the kind of work that that judge did. Now, I pick on the District Court of Texas only because that's what Ted Mervis said. I have no reason to believe that 3 minutes after the explanation, the District Court judge nailed that case just the way he should have. I'm pretty confident he did. We don't care if suits move out of Delaware. The suits we will get will be the important ones, the ones that have a fundamental effect on Delaware law, and the ones where the plaintiffs believe they have a really good case. Because if they bring a good case to Delaware, they might end up with a Del Monte or the Peru case, where the result is of enormous satisfaction, I'm sure, to the plaintiffs, and even more satisfaction to plaintiffs' counsel. One counsel recently complained about the fact that you couldn't get expedited cases done in Delaware like you used to be able to. And there was a room of 200 lawyers, and the chancellor asked, Leo Strine, asked the room, "Wait a minute, how many people here currently have an expedited case?" 2/3 of the lawyers in the room raised their hands. I'm not concerned about people bringing frivolous suits for settlement value based on the value added of uncertainty in another jurisdiction at all. I'm only concerned about cases that fundamentally affect core principles of Delaware corporate law. If they're filed in multi-jurisdictional situations, and by the multi-jurisdictional I mean both federal district court and state courts elsewhere, and one is filed in Delaware, we're happy to yield to the other states. We'll stay our action. We might even dismiss it if it's not a fundamental core principle of Delaware law, but we won't yield when it is. Now, to the extent somebody chooses not to file in Delaware and other courts interpret Delaware law, we have probably 125 cases that say, we're not concerned about that because there's nothing mysterious about Delaware law. It can be interpreted by any other jurisdiction and any other judge. Whether they give deference to the internal affairs doctrine, whether they get it right at the end of the day is another issue. But unless it's fundamentally important to us, we're losing no sleep over it.
Your Honor, you've been terrific. We're 10 minutes past.
Oh.